Hi everyone, my name is Christina Loback and I'm an immigration lawyer at Spousal Legal. This is video number 3 in our series on Canadian spousal sponsorship. In this video, we are discussing what exactly the sponsor is agreeing to when they sign the sponsorship undertaking for their spouse, common law, or conjugal partner. The spousal sponsorship undertaking is a binding contract between the sponsor and co-sponsors, when applicable, and the Canadian government. Sponsors promise to provide the sponsored person with basic requirements from the day they enter Canada as a permanent resident until the end of the undertaking. For spousal sponsorship applications, the length of the undertaking is 3 years from the date the sponsored person becomes a permanent resident. So, what exactly are the basic requirements that the sponsor must provide? By signing the undertaking, the sponsor becomes legally responsible for providing food, shelter, clothing, and everyday living needs for the person they are sponsoring. Anyone who comes to Canada through the family sponsorship class has no access to government-provided support such as social assistance or disability benefits. If the person you are sponsoring receives money from the provincial or federal government, it's the sponsor's responsibility to pay the government back. Now, by virtue of holding permanent resident status, the sponsored person will be entitled to provincial health care, such as OHIP in Ontario, once they meet that residency requirement. However, the sponsor or their private insurer will be responsible for healthcare services that aren't provided by the government, so things like dental and prescriptions. So what if something unexpected happens, like maybe you lose your job or the relationship breaks down and you decide to separate or get divorced? I'm sorry, but once you sign an undertaking, there are no circumstances under which you can end your obligation early. You remain legally responsible for supporting the sponsored person no matter what. The only time an undertaking can be canceled is if you withdraw your application to IRCC before they make a final decision on the application. In Canada v. Mavi, a 2011 Supreme Court of Canada decision, the court reaffirmed the strict duty that applies to sponsors in family class sponsorship applications. To quote the court directly, "The risk of a rogue relative properly lies on the sponsor, not the taxpayer." This case involved numerous individuals who incurred huge debts as a result of the undertaking. So, for example, an individual who sponsored their spouse who then left them and remarried a few weeks later. The sponsor person later received social assistance, and the spurned sponsor ended up owing the government over $22,000. These situations are unfortunate, but ultimately that's what the sponsor agrees to when they sign on the dotted line. I hope this was helpful. For more information on Canadian spousal sponsorship, visit our website at www.csulegal.com.